This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today, I'd like to talk about some professional members of the insurance claims team. And this will start with claims counsel. The insured may meet with an attorney representing the insurer under two circumstances. One, if the insured has been sued by a third person, the insurer will retain counsel to defend the insured at the insurer's expense. Counsel will meet with the insured and work to present the most effective defense to the suit. Insureds most often meet with claims counsel in a situation where the insured is an automobile accident or a third party sues him or her for injuries incurred in such an accident. 2. If there is a problem with coverage or with the extent of the claim, if the insured retains counsel to represent his or her claim, or if fraud is suspected by the insurer will retain counsel to protect its interests. Attorneys who represent insurers in such situations are often referred to as coverage counsel. Coverage counsel will usually deal with the insured's personal attorney, his public or her public adjuster, or directly with the insured. The insured may meet with coverage counsel if an examination under oath is demanded by the insurer to resolve coverage issues found in the investigation of a first-party property claim, or any other kind of first-party claim, such as a no-fault insurance claim. In that case, the insured must, as a condition of the insurance, appear before claims counsel and give sworn testimony. The examination under oath is a formal type of interview authorized by an insurance contract. It is taken under the authority provided by a condition of the insurance contract that compels the insured to appear and give sworn testimony on the demand of the insurer, or find his or her claim or its claim rejected for breach of a condition. A notary and a certified shorthand reporter are always present to give the oath to the person interviewed and record the entire conversation. The EUO, or examination under oath, is a tool used sparingly by insurers in the United States when a thorough claims investigation raises questions about the application of the coverage to the facts of the loss, the potentiality that a fraud is being attempted, or to assist the insured in the obligation to prove to the insurer the cause and amount of loss. Although rarely used, the EUO is an important tool needed by insurers when there is a question of coverage. The adjuster, the independent adjuster, the special investigation unit investigator, the independent insurance adjuster, and in complex cases, the attorney retained to represent the insurer questions the person interviewed in a manner similar to a deposition in a legal proceeding. Because of the formality of the proceeding, it includes an oath in the presence of a certified shorthand reporter. The task of establishing rapport with the person interviewed so that relevant information may be obtained from the insured is more difficult than in an informal interview. Unlike legal proceedings where questions are limited to those seeking a yes or no answer, or brief answers, the EUO seeks narrative responses from the person questioned. and the lawyer who is usually assigned to take the EUO is competent and understands the difference between a deposition or a trial and an examination under oath, and will not ask, usually, questions that only seek a yes or no answer, because it is an information gathering tool. Often, however, the purpose of the EUO is not to stop fraud, but to allow an insured the opportunity to prove his or her claim of loss in cases where evidence has been destroyed by a casualty or is otherwise unavailable. The authority to take an EUO is provided by the insurance contract and exists as a result of statutes establishing a state-mandated fire insurance policy that must be incorporated in every policy in the state that insures against the peril of fire. The language authorizing an EUO follows, quote, "The insured, as often as may be reasonably required, shall exhibit to any person designated by the company all that remains of any property herein described, and submit to examination under oath by any person named by this company, and subscribe the same, and as often as may be reasonably required, shall produce for examination and copying all books of account, bills, invoices, and other vouchers." Close quote. This is from the New York Standard Fire Insurance Policy. Now, the insured must deal with and comply with the requirements of the insurance company, or will lose every right under the policy. Before refusing to defend a policyholder or to provide indemnity on a questionable case, a prudent, knowledgeable, and experienced insurer will seek the advice and counsel of an expert insurance coverage lawyer. A contract and the terms within it are usually unambiguous if the terms can be given a definite legal meaning. However, it seems that whenever a court is presented with a coverage issue, the primary guide to determining the obligations created by an insurance contract is the language of the contracts themselves, and therefore the assistance of competent insurance coverage counsel is often necessary, if not, and always desirable. The insurer desiring to treat its insureds fairly and in good faith will follow the rules of policy interpretation, and with the advice and counsel of competent coverage lawyers make a decision on coverage. When an insurer makes a decision on coverage without a thorough investigation and the advice of competent coverage counsel, there is an insurer following a dangerous path that can lead to the result it does not want, a successful bad faith suit against the insurer. The new plain language policies are not as precise as the language of older policies, and confusion as to meaning is more frequent. The adjuster must be able to put precision into the language and apply it to a particular loss situation. Modern policies now have a long section of definitions that assign particular meaning to many words in the policy. It is up to the adjuster, with the assistance of insurance company management and an insurance coverage counsel, to interpret the language and predict how a court will deal with it if it is submitted for review. The interpretation must be made under fire, so to speak, from a pending claim. thus giving a good reason for claims coverage disputes to be presented to and seek the assistance of a competent insurance coverage lawyer. If the adjuster determines there is a problem that requires legal advice, he or she should consider seeking the advice of coverage counsel with the permission and consent of management. If the adjuster follows the reasonable advice given by an attorney, that advice will often serve as a defense against suits for breach of the covenant of good faith and fair dealing. Most variations in insurance, however, are due to differences in the subjects of the insurance. The promise to insure against accidents involving the use of a car is different from the promise to insure against accidents involving the use of a boat or an airplane. Accidents on a golf course are different from accidents resulting from a manufactured item or a service. Regardless of the promises made by the insurer, the format and structure of property and liability policies are generally the same. When reading a policy, like a commercial general liability policy or a commercial property policy or a homeowner's policy, the counsel must first find out who qualifies as an insured. Second, start the review with the insuring agreement. This is the broadest the coverage is ever going to be. Third, highlight the areas changed by an endorsement. When reading that part, apply the endorsement wording directly, and remember that the endorsement supersedes the basic policy wording. Fourth, compare the forms and endorsements listed on the declaration page or schedule of forms with the forms and endorsements attached to make sure the entire policy is present and is represented by the schedule. This includes confirming that the addition dates stated on the schedule of forms match those of the forms attached. Then, after the insuring agreement, read the exclusions, read the exceptions to the exclusions, since exceptions give coverage back in specific amounts and types. When the policy refers to another section, read that section immediately. Pay attention to the conjunctions used in the list. And is inclusive or is exclusive. Pay attention to key words, phrases, and definitions. Read and understand the definitions of specifically defined terms and consider the special meaning of defined terms when analyzing coverages. Recognize that words not defined are given their common, everyday meaning. Understand and make sure that all the policy conditions have been met. Failure to meet the policy's conditions could result in the denial of coverage. And finally, confirm the coverage limits are adequate for the potential loss or the loss that occurred. Then read the entire policy in one sitting and apply the wording of the policy to the facts determined by the investigation. And if the claims department has difficulties after doing this thorough review of the policy, seek the advice of competent coverage counsel to explain how the coverages apply to the facts determined by the thorough investigation. This video was adapted from my book, Zelma on Insurance Claims, Part 101, Second Edition, and is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you, pass it on to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn of future videos and future blog postings. Thank you for your attention.